Hello everyone, welcome to our third lecture of professional responsibility for the NCA examination. So today we are going to cover two topics under our part B, ethics, lawyering and professional regulation. So firstly we'll talk about conflict of interest related to our clients, like when the interest of current client clashes with the former client. So what we have to do in that situation. Then adversary system, the advocacy, how lawyers have to represent themselves as an advocate in the court. So we will be discussing these two topics. Now let's begin. Under first topic, conflict of interest, we are going to firstly see when does lawyer-client relationship come into existence. Somewhat we have discussed this in previous chapter also. You might feel like okay, things are getting repetitive, but this is how the syllabus have been formulated. So things do overlap, but does not matter. We have to follow every topic again and again. So origins of conflict of interest, how the conflict starts out of this relationship. What are the sources? What are the types of conflicts? Then client loyalty, changing forms, potential conflicts involving law student, lawyer, then avoiding conflicts, what are the remedies available, how withdrawal happens, implication, effect for consequences for lawyer, client, and the administration of justice if somewhere conflict of interest happen. And here I would like to tell you one thing, that in examination you are going to get a question related to this topic, conflict of interest, 100%. Is the current balance largely framed by example of Supreme Court of Canada in Martin, Neil, Strother? So we'll be following all these four cases. So last is this way of conflict of interest formulation, the balance that these cases have put forth, is this sufficient? Has these cases done their job in clearing out the picture related to conflict of interest? So we will see that. Then next topic, adversary system, lawyers as advocate. Firstly, we'll see how adversary system works, its impact on professional obligation. Lawyer as advocate, then sometimes lawyers work as counselors also. Truth and rights, candor, zealous representation. We have talked about these things earlier as well. Here, these are full-fledged separate topics. Duties to clients, opposing counsel, court, other parties, and societies as an advocate when you are before the court of law. Civility, decency, document production, trial tactic, evidence and disclosure, and last is witness preparation, conduct, and perjury. So, starting with conflict of interest. So, in today's modern day, what we see that a lawyer's ability, capability to provide legal representation to client with undivided loyalty. This has become a very crucial, intricate, complex matter because so many things are involved. Today, the lawyer profession is not that simple. The representation is not that simple. We know that there are big law firms that are involved, then few multidisciplinary larger law firms, international law firms are involved. So how we have to maintain a balance in this profession, how we have to avoid the conflicts. So we know that lawyer-client relationship is a fiduciary relationship. What do we mean by fiduciary? Based on trust. So this is Model Code 3.4 and Commentary 5. Fiduciary relationship, duty of loyalty and conflicting interest. Consequently, lawyer has a duty of loyalty to his client. We know this thing. Duty of confidentiality, secrecy, we know. Frankness, candor, then commitment to client's cause. You have to give your best. All these things come under duty of loyalty. Conflict of interest rule shelters all these duties from impairment. So what conflict of interest rule does? It says we are shielding all these principles so that no client can feel disloyalty from his or her lawyer. That is, conflict may occur when a lawyer has information from one client that is relevant to another one of his client or a prospective client's matter. So when such conflict of interest situation arises, what a lawyer has to do? Lawyer's duty is to one client not to divulge the information but owes a duty to the other client also, or prospective client, to reveal the information. So here a lawyer cannot fulfill both the duties. Lawyer is in conflict of interest. For example, you have a client. Somehow something happens, like you change your law firms, or there's some termination of your retainer agreement. Now you have a new client, your current client, but the current client brings a case, your legal representation, against your previous old client. So now what will you do? So here conflict of interest situation arises. We will see what are the rules, how a lawyer has to deal these kind of situation. As per Alice Woolley, no area of law governing lawyer consume more lawyer time, create more confusion, frustration, or causes lawyer more difficulty than rules governing conflict of interest. So Alice Woolley says that this is the area where there are conflict between the clients themselves. Their lawyer has to give maximum time to make this situation peaceful, to bring a cooperation, to remove this conflict of interest. So this is the area where lawyers consume maximum time. So as per Model Code 3.4, lawyer's duty is to avoid conflict of interest. Lawyer must not act or continue to act for a client where there is a conflict of interest, except as per the guidelines, as per the permission given by the model code. So what are the examples? So examples where conflict of interest might arise are given under commentary 11. According to Law Society of Ontario, steps for dealing with conflict of interest rules. So part 1, how you have to deal. So determine if there is a conflict of interest, identify the conflict, what are the issues. So secondly, if you find out that okay, there is a conflict of interest, then you have to say whether you can take your case further, whether you can act further without looking into that conflict of interest, or does that conflict of interest needs your attention, needs to be resolved. So here you will stop if you think that conflict is such that you cannot act further. So firstly, you have to follow these two steps. Then there are two main dimensions. So two kinds of conflicts arise. Firstly, when there are conflicts between the clients itself, so arise between or among client. Secondly, when there is a lawyer client conflict, so these arise due to potential conflict between lawyer's own interest, personal interest, and those of the client. So there are two situations. We will be covering all these situations one by one. Again, in examination you might get question on this, you might get question on this, or combined both. This is very important topic. So for client-client conflict, Supreme Court of Canada has decided three major judgments in the area of conflict of interest. These are known as conflict trilogy. If you get a question on client-client conflict, you will be mentioning, you will be referring to all these three cases in your answer. In each case, behavior of lawyer fell short of the standard. So here in this case, what happened? The lawyer moved further without resolving the conflict. So there was straightforward conflict of interest. Rule 3.4 to 3.4, 10, 11 and commentaries address acting against former clients. Model Code 3.4, unless the former client consent, a lawyer must not act against. So for example, as I told you earlier in the illustration, that for example, you have a client that is no longer your client. It means what word you will use for that client, for an old client, former client. So if you have to legally represent a person, your new client, and the case is against your former client, in that scenario, as per Model Code 3.410, you cannot move further with that case without having consent from your former client. Same matter, any related matter, any matter, if the lawyer has relevant confidential information arising from representation of former client that may prejudice, that might be against that client. So in these three situations, you cannot act against former client without client's consent. So first case, trilogy case number 1, McDonald Estate versus Martin. So firstly, let's look into the facts. Appellant solicitor was assisted by a junior member of his firm who actively worked on the case. What does this line suggest? This line suggests that that junior member also had almost all the important information related to solicitor's client, was privy to many confidences disclosed by appellant. Junior member later joined the law firm which represent respondent in this action. So who was the respondent? The junior member who earlier worked with the solicitor for appellant's case later joined another law firm where he represented the opposite party. So for junior member, this person is a former client here. Appellant applied to Provincial Superior Court for a declaration that law firm was ineligible to continue to act as solicitors of record for respondent. The court granted the application, ordered the firm remove a solicitor of record. So court ordered to remove this person. Court of Appeal reversed that decision. What is the standard to be applied when considering disqualification due to conflict of interest? So here earlier the court only removed the solicitors of record, but Court of Appeal reversed the decision. Court of Appeal said that in this case the person has to be disqualified, has to be taken out from representation as there are clear-cut conflict of interest. So three competing values were highlighted by court in reasoning. So firstly, court said that to maintain high standard of legal profession and integrity of our system of justice, then countervailing value that a litigant should not be deprived of her choice of counsel without good case, permitting reasonable mobility in legal profession. So all these three competing values are there. So whenever there are some conflict of interest, the court comes into picture, the court takes strict action. Would a reasonably informed individual of public be satisfied? So this is the test that court applies. How court comes to this decision? So of no use of confidential information occurred. So two answers. So court says that in order to see whether the junior lawyers shifting to new firm and then representing, having already the information of the older client, the appellant, does these include conflict of interest? So we have to see as a general public what a reasonable person from public would say in this situation. So you have to answer two questions. Did the lawyer receive confidential information attributable to solicitor-client relationship? Firstly, you have to see how much information and whether there was any confidential information. So in the facts, we saw that it was clear-cut written that the junior lawyer was privy to some important confidential information. Is there a risk that this information will be used to prejudice the client, against the client? So 100% definitely. So both the answers are yes. Once it is shown by client that a sufficiently close relationship exists, court should infer that confidential information was imparted, misused by the tainted lawyer, unless the solicitors satisfy the court on basis of clear and convincing evidence that all reasonable steps were taken to ensure that no disclosure happened. So in this case, this test as a reasonable person applied. Miss Dangerfield actively worked on the very case in respect of which her new firm is acting against former client. She is therefore 100% possession of relevant confidential information. In terms of misuse of information, the affidavit stating that no discussion of case have occurred or will occur is not sufficient. An affidavit is not sufficient to demonstrate that all reasonable measures were taken. So there is nothing in the evidence that shows that any independently steps were taken by the firm, the previous firm, to implement any kind of screening on the lawyer, that they have checked that the junior lawyer does not have any important information that can be used later on against their client. So no such steps were taken. The firm may therefore not continue to act. So this was held. Very simple, straightforward case. Then model code rules 3.4, 3.4, 1 and 3 commentaries deal with current client conflict. So this is related to, we are talking here, current client. Lawyer must not act or continue to act for a client where there is conflict of interest. This we read earlier as well. So lawyer have an ethical duty to avoid conflict of interest. So as per the morals also. Then trilogy next case, here bright line test. This test comes up R versus Neil 2002 case. So let's see what happened in the facts. Neil was an independent paralegal. He sought legal representation from V for charges of misconduct in regard to his work and capacity as a paralegal by Law Society of Alberta. Neil was additionally charged for being a part of an alleged scheme to defraud Canada Trust. He sought stay. So Neil sought stay of criminal proceeding on ground that the firm that was representing him had a conflict of interest. What was the conflict of interest? So V represented Neil while Lazin, who was one of V's lawyer. This person's lawyer was representing Neil's former business associate. Neil's former, some old business associate Lambert. And here Lambert was the co-accused. So in separate action involving family law, especially divorce proceeding, Lazin encouraged the new client to report evidence that was forged by Neil. So in separate action which involved another case, not these criminal charges, but completely different family law, specifically divorce proceeding, Lazin, who was V's lawyer, encouraged the new client to report evidence that was forged by Neil. Therefore, firm provided evidence that assisted their new client in a divorce case, but that negatively adversely impacted Neil because this case forgement was used here in the criminal proceeding that were being laid against Neil. So Neil, another one of their client in Canada Trust case. So here in this case, it impacted. So issue was, what are the appropriate proper limits of a lawyer duty to loyalty to current client in a case where confidential information was not departed upon the lawyer that was relevant to the matter in which he proposes to act against current client's interest. So the issue in simple words is, to what extent duty of loyalty of lawyer to current client extends where confidential information was not departed. The lawyer himself did not have any confidential information but got that information from some other sources. It was relevant to the matter in which he proposes to act. So the lawyer here definitely has conflict of interest. So what was held? In both cases, the same member of firm, Lazin, had a finger in each of the conflict situation. So Lazin is the common party, same member of the law firm. He is involved in the conflict situation. Value of an independent bar is diminished here unless lawyer is free from conflicting interest. Loyalty encourage bolster effective representation. So all these things have been held by the judge. Duty of loyalty is interwoven with fiduciary nature. Lawyer may not represent one client whose interests are directly against immediate interest of another client. Very simple. This is general rule. Even if both the matters are unrelated, does not matter. Like if you're getting, there are two cases against a person, you're getting an information from the other case and you're using it in your current case, so that definitely questions your loyalty. So even if the two mandates are unrelated, like in our case, what happened? There was one family law case, one criminal law. The material from family law case was used in the Canada Trust case. Unless both client consent. So if consensual is there, then there is no issue. So we law firm, Lazin specifically put themselves in a situation where the duties they undertook to client conflicted the duty of loyalty, so which they owed to appellant. So duty to client has three components. So firstly, it includes duty to avoid any conflicting interest. This is a bright line rule. You cannot represent a client whose interests are directly adverse to immediate interest of another client. For example, you are a law firm, you have two clients, you cannot represent one client whose interests are immediately affected by the another client. It means you cannot represent both parties to a case, appellant and respondent both. You cannot be lawyer to the in same case or even in different case, but related ones. If they are affecting one to the another in some way or the other, then you cannot represent such person, you cannot take up that case. Duty of commitment to client's cause, duty of candor, frankness on client's matter, breach of loyalty was found in this case. So what judge said? He said, in my view, the law firm did owe a duty of loyalty to appellant at the material time. Law firm ought not to have taken up the case. Law firm should not have taken up the case of one of the appellant's alleged victim in proceeding before civil court at the same time, where simultaneously matter is already pending before criminal court. So you cannot take up similar cases. Even if in a law firm there are two different lawyers, but client is same and one case is affecting the other case, you cannot take up that matter. Bright line rule says a lawyer may not represent one client whose interests are directly adverse to immediate interest of another client, even if two mandates are unrelated. So this is the bright line rule. So after Neil case, many commentaries, many controversies came related to current client conflicts. Devlin and Rees, they contend Binnie J in the Neil case what the judge said, enunciated quite carefully the court's reflection on duty of lawyer, also made it clear that a business conflict can now be a legal conflict because loyalty include putting client's business ahead of lawyer's business. Malcolm Mercer says there are some real policy program with this rule which was formulated in Neil's case. The rule applied in situation where there was no real risk of mischief. He said both the cases were different, there was no real risk of mischief. Naturally, some sophisticated clients prefer to keep control by stating that express consent is always required, thereby defeating the prospect of implied consent. He said one should have an implied consent. If a client is putting forth another case before the same law firm where he has already having another case, then it means that the person has already given implied consent. While flexibility is remedy is helpful where disqualification is sought from the court, this remedial flexibility is of limited if any assistant in day-to-day conflict. So consider the practicality of bright line rule, he says. Especially in today's modern legal workplace where firms are growing in size, more cases are coming up, complexity and handling hundreds of cases at the same time. So these were the few criticisms on Neil's case. Then Model Code 3.4. So this we have already read. Then Commentary 5 talks about duty of loyalty. Lawyer-client relationship may be irreparably damaged where lawyer's representation of one's client is directly against another client. So Commentary 10 says, firstly, identify the conflicts. Factors for the lawyer to consider in determining whether a conflict of interest include. So what are the factors? Firstly, see immediacy of legal interest, whether any immediate interest is affected, whether they are directly involved, directly affecting another client, whether the issue is only substantive, theoretical in nature, or it is related to some procedure, some rule. Temporal relationship between matter. Significance, importance of issue to the immediate and long-term interest of client. Client's reasonable expectation in retaining lawyer. So now next is former client conflict. We are done with current client. Now former client. What degree did the judgment in Neil provide insight into standard applicable in circumstances of alleged conflict of interest involving former client? So Neil did not extend the duty of loyalty to former client. The Neil's case only clarified the difference between duty of loyalty and duty of confidentiality. To what extent you have to keep things secret and to what extent you owe a duty of loyalty. So Neil's case only talked about these two simple things. Even if a duty of loyalty allow a lawyer to act against former client, duty of confidentiality secrecy may disallow. So what happens in this case? This is a more complex scenario. So duty of confidentiality secrecy continues even after your retainer agreement has ended. Your duty of loyalty sometimes just go till the time you are representing a person. But duty of confidentiality secrecy, that is a bigger duty, it continues to the whole time. So confidentiality duty may conflict with duty of candor owed to a current client if information from former legal matter pertains to current matter. So they say, what about duty of candor? You are saying frankness. You have to be frank, open with your current client. But when you are saying openness, are we allowed to share any formal legal matter, any formal client's information that is related to this current client? What about secrecy concept? So here you can say that duty of candor and duty of confidentiality are in conflict. So there is a difference between same or related matter and new matter. In terms of former, a lawyer must not act against a former client in same or related matter. So this is the thing. Here, this duty of confidentiality only extend if the case in which the former client is involved is related to same matter or related matter, or if the former client consent. So consent must be fully informed and voluntary, no coercion, no pressure. So this thing clears out our picture. This thing clear out our confusion. So in case there is a completely new matter, then you have no duty to your former client. So what about new matter? Let's look into this in detail. When a lawyer has acted for a former client and obtained confidential information related to new matter, another lawyer in the lawyer's firm may act in the new matter against the former client. So what happens if there is a new matter? The same lawyer who represented that former client cannot represent any other new lawyer can represent from the law firm. And what are the situations? Firstly, the former client consent. Secondly, the lawyer, partner, or associate establish in the interest of justice that it act in the new matter having regard to all relevant circumstances. Also, that there would be no disclosure of former client's confidential information to other lawyer. The lawyer who had this particular person's information, that lawyer will make sure to the former client that he or she is not gonna share that information to the other lawyer. Adequacy, timing of measure taken to ensure no disclosure, extent of prejudice to any party. They will see that whether representing a former client or having information about former client and now representing current client, new client, will there be any injustice, discrimination, prejudice to any party? Will there be any harm to any party? Good faith, you have to work in good faith, no sharing of any information. Then availability of suitable alternative counsel. Is there any alternative counsel available? Are there any options to go for that party to some other law firm, completely something new? Issues affecting public interest. So for this, let's look into another case, trilogy case number 3, Strother versus 3464920 Canada Incorporation 2007 case. Facts: Robert Strother, he was a senior tax partner at law firm Davis and Company. So in Davis and Company, Robert was a tax partner. His expertise specialty were film-based tax shelter investment. Initially, he represented a company called Monarch Entertainment. So this was his previous employment company. This representation was under an exclusive retainer agreement. So he was retained by Monarch Entertainment for some time in a case. This person, Robert. This agreement, this retainer agreement prevented Davis and Company from acting for clients other than Monarch in regard to tax shelter scheme. So this particular Monarch Entertainment under this retainer agreement said that this law firm Davis and Company can only represent them You cannot represent any other client related to tax shelter scheme other than Monarch. Federal Minister of Finance announced his intention to alter the IT Act to defeat tax shelter. The changes to tax law would get rid of film-based tax shelter. Strother told Monarch, this person, who was a senior tax partner who was representing on behalf of Davis and Company, Monarch Entertainment, the shelter vehicles were essentially dead. He said he did not have a fix to avoid the effect of rules. Monarch wound down its business and retainer with Davis Company expired. So Strother, based on this announcement by Minister of Finance, told Monarch Entertainment that okay, your tax things would no longer be that beneficial, you can just take them down. So Monarch, on listening to Strother's advice, shut down his business, and as a result, the retainer agreement with Davis Company also expired. So next, Dark, a former old Monarch employee, he came to Strother with a plan for circumventing the government policy. He said, I have an idea, we can just circumvent the government policy which is related to this new tax thing. Strother agreed to help Dark in starting a business and getting a favorable tax ruling. So you see, Strother earlier advised something to old client Monarch and shut down their business related to same thing. Now helping one of the employee from Monarch only to start business related to same thing, same favorable tax ruling. So Strother himself became partner with Dark in this new business, Sentinel. I hope the things are clear till here. Strother did not inform Monarch about the possibility of a revival in film production services business at any time. So when Strother told Monarch about this government policy, did not inform anything that okay, in future this might happen, or there are few things, there are few policies which we can circumvent and your business could be revived. So favorable tax ruling was issued by Revenue Canada. Strother did not advise Monarch of the existence of this ruling. So Strother hid some things. Throughout 1998 and into 1999, the law firm continued to do some work, some outstanding matters for Monarch related to film production services transaction. So still Strother was, his law firm was somewhat continue to act as legal representative for Monarch. Once Monarch learned about the situation that their former employee Dark and their lawyer Strother are doing something related to this, Monarch sued Strother and Davis and Company. So question is, did Strother and Davis and Company violate their duty to Monarch? Despite the fact that Monarch's tax shelter retainer had expired, Monarch still retained in a limited capacity legal services because cases were still going on. So did Strother have a duty to provide candid advice? So good advice, loyalty, candor, frankness, all these things come under your duty of loyalty as a lawyer, your fiduciary relationship as a lawyer. So what was held? The main issue was not really about an obligation duty to change a past opinion. It was about Strother's duty to offer a good candid advice to all matters related to continuing 1998 retainer. There was no reason for Strother to not advise Monarch for successful tax ruling. Here, what happened? Strother himself became selfish. His personal interest came into picture. So that became the reason of conflict of interest. So Monarch found about tax ruling late in the game. Nonetheless, because Monarch was unable to prove any damages flowing from alleged contractual violation, did not succeed in damage claim for breach of contract of retainer, issue moves to fiduciary duties. Like I told you earlier, loyalty, fiduciary relationship. Technically, Film and Strother were not restricted from taking Dark and Sentinel as new client once exclusivity agreement with Monarch expired. Monarch could not have consented to conflict of interest because it was left in the dark. Monarch did not knew about this consent and anything. So that is why he did not take up this point. There is no doubt that at all material time there was a current meaningful solicitor-client relationship between Monarch and Davis Strother to ground of loyalty. And these are the cases in which this happened. The judge highlighted these cases. Monarch was current client, undeniably entitled to continuing loyalty. So there was no loyalty on behalf of Strother to Monarch. Lawyer must not keep the client in dark about matters he or she knows to be relevant to the retainer. So this is the duty of candor. So this was missing, duty of loyalty was missing, there was no fiduciary relationship by becoming a partner in new business. So here, like I told you earlier, his personal financial interest comes into picture. So these were main reason of conflict with his duty to monarch. Taking direct significant interest in potential profit of monarch's commercial competitor created substantial risk that his representation of monarch would be materially adversely affected by considering his own interest. So, in other words, he breached and violated his duty of loyalty undoubtedly. At the end of the day, Strother could have easily fulfilled his duties as a lawyer, satisfying the duty of loyalty and candor. So, these two things were missing. So, this is what justice has said. Again, similar things, that what are his duties, then he should have respected duty of confidentiality. Then there is nothing that could justify that why he did not consent it to monarch, why he did not told monarch about this new policy. So what was the reasoning? So Davis and Company Strother failed to provide candid proper legal advice. This was in violation of retainer agreement. Number two, duty of loyalty, nowhere seen. So Strother breached his duty of loyalty to monarch. This is the main thing that happened. So what was the important significance of this case? So the Strother case has important implication for all lawyers. Supreme Court reaffirmed the bright line test in R versus Neal. So while the scope of a lawyer's retainer is governed by contract, lawyer-client relationship is based upon fiduciary responsibilities. So that goes beyond the contract. Loyalty include putting client's business ahead of lawyer's business. So whenever in examination you get a question and you see that okay, there is no issue with the retainer agreement, that is expired, the client cannot question the loyalty on that, there are no conflict of interest related to that, you will have to then go to number two test, that is fiduciary duties. And under fiduciary duties you will have to check everything whatever is mentioned in the model code 3.4. Lawyer must be candid in their advice to the clients, must not divulge confidential information to other, so there should be no conflict of interest. Then another very important case, Wallace versus Canadian Pacific Railway 2011. A law firm McCurcher LLP started a class action on behalf of Gordon Wallace against, among others, Canadian National Railway. At the time it initiated this McCurcher LLP, Wallace claimed this company was acting for Canadian National Railway on a number of other unrelated matters. So this term unrelated is important. When this company, Canadian National Railway, found out that okay, this McCurcher LLP is also representing Wallace, it applied to the court to disqualify McCurcher from acting on claim due to an alleged conflict of interest. Court set out three primary questions. Firstly, whether McCurcher gained material confidential information about Canadian National Railway while acting for it prior to and at the time Wallace claim was initiated. Secondly, by acting for Wallace, has McCurcher breached its duty of lawyer? If the first two inquiries is answered as yes in affirmative, whether any proper remedy was taken by McCurcher or it should be disqualified. So the judge said McCurcher did not gain any confidential information that could be used against Wallace. However, McCurcher did breach its duty of loyalty in respect of its commitment to CN, in respecting to its CN file, and also in respect to duty of candor about taking Wallace claim, should have told CN. So CN falls short on remedy for that breach. Although CN may have a basis to complain Law Society, McCurcher should not be disqualified from acting on Wallace's claim. I would accordingly allow the appeal. So appeal was allowed. The bright line rule again was highlighted here. Absent proper consent, a lawyer may not directly act directly adverse to immediate interest of current client unless the lawyer is able to demonstrate there is no substantial risk that lawyer's representation of client would be materially adversely affected by new unrelated matters. So this happened in Neil versus Strother. This was used. So the main issue, the failure of McCarthy to advise CN in a timely manner to ask for the consent that it intended to take Wallace crime, demonstrate complete lack of frankness, candor. Although breach of loyalty did not compromise here as there was no usage of any confidential information, it was held that disqualification was too harsh just on the basis of lack of candor and that it would be fairly disadvantaged for Wallace. So firm's lack of candor is best left to profession's disciplinary body, but the firm will not be disqualified. So disciplinary action could be taken by law society, but as such, just based on lack of candor, the firm cannot be disqualified from taking up Wallace case. So then another case, again almost similar things in 2003 happened. Here it said that lawyer must not keep the client in dark about matters he or she knows to be relevant to the retainer. CN should have been given the opportunity to assess McCarthy's intention. So in this case, they held that in furtherance, this was the case in furtherance to this, the previous case, that the court said that CN should have given proper time and opportunity to see that whether taking up case by McCarthy for Wallace is not against CN. CN should himself be satisfied. So and CN will take appropriate decision in the response, whether to terminate his existing retainer or continue, or to take any other action. So lawyer-client conflict. Next, earlier we talked about client-client conflict, and in that we took up two situations: current client, former client. Now we are coming to completely different category of conflict of interest, lawyer-client conflict, where the conflict which has arisen interferes with duty of loyalty to the client by lawyer with his or her ability to provide uncompromised representation, fair representation. So whenever there is uncompromised representation, there is compromised representation, then lawyer-client conflict come into picture. So in this case of 2014 Law Society of Upper Canada versus Caminer, if a lawyer has a sexual intimate personal relationship with client, this may conflict with lawyer's duty to provide objective disinterested professional advice. Consequently, lawyer may be placing his own personal interest, whether of sexual or personal nature, above that of client. So this was happened. So no such interest has to be brought into forth by the lawyer. Stewart versus Canadian Broadcasting Corporation. Plaintiff Stewart ran over Miss Jordan with his vehicle, dragging her to death. Stewart retained Edward Greenspan as his counsel, convicted of criminal negligence causing death. Following sentence, what happened? Defendant Canadian Broadcasting Corporation televised a reenactment of crime and trial. Whatever happened, using Greenspan as the host and narrator. So Stewart had this Edward Greenspan as counsel. Later, a broadcasting corporation televised this whole incident on TV in the form of a show, and they used Greenspan as the host and narrator to tell the whole story. Was there a fiduciary duty of loyalties to Stewart, and if so, did the duty require Greenspan to refrain from such involvement in the broadcast portrayal of subject matter of his concluded retainer? So Greenspan said he claimed that in defense, he desired to do the program for its educational value, despite Stewart's objection to it. Although there is a vital societal benefit of knowing about cases before the courts, I reject conclusion counsel has the right to refer publicly to any non-confidential matter. So the court clearly said that here Greenspan's primary purpose was to publicize himself and his services to national audience, and this step basically prejudiced his client Stewart's interest. So broadcast was not right, it was not just. confidentiality matters are not relevant to deciding the fiduciary issues in this case. A lawyer is not bound indefinitely to serve a former client's interest, but Greenspan violated fiduciary duty of loyalty. Firstly, he favored the financial interest that he got from the television company over plaintiff interest. He placed his own self-promotion through television. The manner in which he publicized his former client undercut the benefit protection he had provided as counsel, enhanced the adverse public effect on plaintiff. So fiduciary relationship was existed which was breached 100%. So what are the remedies? In notes, I have mentioned few summarized details so you can follow that as well. So after that, we'll be talking about remedies. What are the options if there is some breach of interest? Firstly, lawyer causing the conflict may be disqualified from representing the lawyer. Secondly, it could be complained to law society. Legal action could be taken for compensation. Then, any benefits or profits that the lawyer has got, disgorgement of all those benefits could be taken back. Any law firm's profits could be taken back. Accounting for and disgorgement of any legal fees during the period of conflict. Then, disqualification of preserve integrity. Disqualification may be necessary to prevent the improper use of confidential information, ensure adequate representation, and uphold the reputation of administration of justice. What are the implications for lawyer-client administration of justice? Judgments rendered by court, particularly the landmark decision R versus Neal, have significant implication for legal ethic, lawyer-client, and administration of justice. So firstly, the R versus Neal case sparkled the intense debate among legal commentators. As we talked earlier, few gave their criticism, few suggested that okay, this is a good decision. Then we got clarity on loyalty. Then we saw priority of loyalty over confidentiality. Then there were few shift in standards, that how, to what extent it is prohibited, if the parties consent that okay, it's good to go. Then heightened risk of disqualification, inadequacy of provision we saw, concurrent representation provisions we saw related to client disclosure, consent, then separate representation within the firm, dispute resolution mechanisms. So overall decisions underscore the paramount importance of undivided loyalty in legal practice, highlight the ongoing challenges in managing. So still we are facing challenges. It depends upon case to case how we take up it. So last is the question of whether current balance that we saw in all the previous cases, four important landmark cases, is fair and sufficient in this complex matter of conflict of interest. So the case of Ontario versus Chartis Insurance Company of Canada sheds light on challenges. They say that despite the efforts of new law firm to prevent disclosure of confidential information from transferring lawyers' former client, court found many a times that significant time spent by transferring lawyer or unrelated matter with a new partner could reasonably lead to conclusion that confidential information might be shared. So there is a potential gap still between technical compliance with ethical guidelines. Some firms say that okay, we have done the screening, there is no prejudice to clients' information, but how can you say that? If there is something that is retained in a person's mind, how can you just erase those information? So that is questionable. This scenario suggests that even with established rule and screening measure, there may still be instances where breaches occur that raise question about fairness, efficiency. Ultimately, assessment of fairness, efficiency in current balance hinges on various factors, depends upon various factors. So the ability to uphold secrecy in practice, any broader implication of administration of justice. So ongoing scrutiny, adaptation of ethical guidelines and legal standard may be necessary. So we still have to see to what extent we can save conflict of interest from happening. So this question is still unanswered. Next is adversary system. So in adversary system, we study lawyers, their duties, their responsibilities as advocates. So the duty and responsibility of lawyer as advocate in adversary system are outlined in provincial rules of professional conduct. province to province, every province have their own rules and regulations, which often align closely with Rule 5.1 of the Model Code. These guidelines emphasize the lawyer's duty to vigorously advocate for their client while adhering to principle of fairness. So what does these rules say? They say that okay, you have to represent your client in your best manner, but you have to side by side follow the ethical moral principle of fairness, respect, honesty. So commentary 1 to rule 5.5 says in adversarial proceeding, lawyers have a duty to their client to zealously, in their best manner possible, represent their interest by raising every relevant issue, advancing all available argument, asking any necessary questions, regardless of how distasteful they may seem. This duty extends to seeking every available remedy, defense. However, lawyers must fulfill this duty through fair, honorable means, avoiding any illegal, unethical conduct. So, this is important. Furthermore, what other duties lawyers do have? So, lawyers are obliged to maintain professionalism, decorum in the courtroom, peace and order, any other setting where disputes are resolved. This includes treating the tribunal, opposing counsel, all parties involved with candor, fairness, courtesy, and respect. Upholding dignity, decorum, courtesy is important to ensure that the legal process functions effectively properly and that the rights of parties are protected. So lawyer must follow all these things. As an advocate, firstly, the lawyer should do a loyal advocacy, then follow the moral codes of principles, then follow the integrity model. So lawyer has to see how to balance various conflicting interests as we discussed earlier. So these are the three important roles of a lawyer. Commentary 5 to Rule 5.1 emphasized the importance of prioritize client view over lawyer's own opinion. Additionally, lawyer must navigate conflict between their duty to the clients and duty to court, as outlined by Lord Danning in Rondell versus Worsley. This duty to court is paramount and require lawyers to act with honesty, integrity, and fearlessness. So this is the commentary. So lawyer should refrain, should not express any personal opinion on merits of the client case. His duty is not only to client, his duty is to the court as well, which is of most importance. So this is what Lord Denning said. So lawyer should have a talent of balancing ethical and professional challenges that could be arise before trial, during civil litigation, during initial meeting with lawyer and client at every step. So lawyer should be well versed as an advocate. So duty of lawyer and advocate include representation of client honorably, resolutely, but within the limits of law by doing nothing unethical, nothing illegal. So while also treating the tribunal with candor, fairness, courtesy, and respect. So balancing these duties is the real talent of a lawyer as an advocate, and this requires careful navigation of ethical consideration and legal duty. Now, what a lawyer do as a counselor? So sometimes the client comes to you as a when you are acting as a lawyer with specific obligations under professional rule. So counseling typically involve in private setting, private meeting, unlike litigation that happens in court. So lawyer must navigate an ethical balance between advancing client interest and adhering to professional conduct rule, even if something is happening like counseling session outside court. So one challenge that is faced by lawyer when counseling client is avoiding merely telling the client what they want to hear. So ethical constraint prevent lawyer from distorting the law to align with client desire. So based on your ethical principle, you are not here to please client. Tell everything whatever is the reality, no matter how distasteful is, no matter how hard is it to accept. So instead, counselor should offer independent candid advice about what law requires, even if it differs to client's preferences. So this is what I just told you. So during counseling, lawyers often explain the law, their application, that to what extent the lawyer's knowledge says that okay, the client's case could be this much meritorious or could be the client could win in the court or client could lose in the court. So you should not bring anything that could misguide your client. So bring forth, even if it is not a proper advocacy before court, even if it's just a counseling, lawyer should explain the law and application to client situation, provide legal opinion, guidance on how to proceed. It's essential here to be honest, clear, candid. Next important thing is lawyer can never. So this code 3.27 rule prohibits a lawyer that if somebody comes to you as a client and he says, okay, I want to do something illegal, I want to commit this crime, that this model code rule prohibits strictly lawyer from knowingly helping or encouraging anyone to do something dishonestly, fraudulently, something of criminal nature, illegal nature. So lawyers should smartly act in this situation, seek clarification, clear out all the doubts if they suspect or doubt involvement in dishonest or illegal activity. In case where a lawyer advises a client to challenge or test the law by technically breaching it, the lawyer must ensure here, because this is what you do. You see the loopholes in between the law, technically you try to save your client. This is your duty. There is nothing wrong in this, but provided this is in good interest and on reasonable ground. So in this situation, lawyers this code permits lawyer to advise client in such manner provided no injury or violence is involved. Client understand the consequence of their action. So rule 3.27 places a burden on lawyer not to only refrain from knowingly helping client in doing something illegal, but also to avoid action that would assist encourage misconduct when the lawyer ought to know better. So lawyer because himself know better that this is something illegal and what would be the consequences. So ignorance of client's wrongful action may not serve as a defense if the lawyer should have been aware, because we cannot expect a lawyer to not be aware of law. So here, if something is happening and tomorrow this comes into picture before court of law, before police, before any investigation, lawyer cannot take up this defense that okay, I was not aware that my client is asking me to do something illegal, because this is what someone can least expect from you as a lawyer. So truth and rights, honesty and truthfulness are the basic fundamental principle in legal profession. Both are outlined in model code as well as professional conduct also from time and again. So lawyers are expected to maintain integrity and be forthright with their clients at all time. So maintaining this ethical balance is important because some lawyers may misrepresent their knowledge or experience to gain clients' trust or justify their fees. So lawyers must be cautious not to engage in any such practice like misrepresenting the amount of work that okay you are telling your client that okay I'm doing extra work, but in reality you are not, you are getting some extra fee, unjustified fee. So these are the things that does not come under honesty and truthfulness. You are providing incorrect statement about completed work. You are assuring availability to meet with the client, but then you are not showing up. Assuring availability to work on a matter, then you are not honest, you are not providing your 100%. Misrepresenting experience and competence. You don't have qualification, but you are fraudulently saying you are making false claim about your competence. So all these things are against the rules of truth and rights. Then candor. Duty of honesty and candor is paramount, is most important. Candor means frankness. You have to be straightforward. You must disclose all the important factors. Then your competence and knowledge should be in your best manner possible. Lawyers must be competent to provide the advice required by the client and must have sufficient knowledge and relevant fact. If a client seeks advice beyond lawyer's expertise, like any financial business advice, lawyer must directly, straightforward, candidly communicate any limitations that okay, my knowledge, my competence is till here only on this matter. I cannot give you any kind of suggestion, any kind of advice. You have to go to some other person for this. You cannot basically misguide any person. Prompt notification of error. If a lawyer makes an error that could harm the client interest, Lawyers have a duty to immediately notify the client and discuss the next potential steps to correct it. Then, if a lawyer has an interest in client's transaction, they must disclose this fact to the client and recommend the client to seek any other independent legal advice so that there should be no conflict of interest. Next is zealous representation. Zealous representation means you are trying to represent a particular person and you want to win the case by any means. But zealous representation does not mean dishonest representation. Lawyers must ensure that their zealous representation aligns with the underlying purpose and process of legal justice. There should be no inconsistent manner in your acting as a lawyer. Bona fide, in good faith, you have to just fight the case. Lawyers should refrain from initiating, starting any claim that lack bona fide dispute. So if there is like baseless dispute. Despite zealous advocacy, lawyer must not interfere with impartiality of decision makers such as judges or jurors. Legal proceedings are governed by rules designed to maximize the pursuit of truth, such as rules related to witness examination, evidence disclosure. Lawyer must adhere to these rules. Whatever the rules of law, lawyer must follow those rules, even in their zealous representation, to uphold the integrity of legal process. So, lawyer has to, at every step, make a balance between professional responsibility and duty towards towards client. Then what are the general duties of a lawyer to client, opposite counsel, court, other parties? So to client, to represent him fearlessly, zealously, in the best possible manner without any fear, endeavor to obtain every remedy defense authorized by law, avoid waiving, abandoning the client's legal right without informed consent, dissuade the client from frivolous objection or dealing tactics. So any kind of illegal thing, you have to tell your client that okay, we cannot do that, that is illegal. Protect client from unjust conviction except by a competent court upon sufficient legal evidence. Uphold client's interest while adhering to ethical standards. So this is the most important thing. Even if client admits guilty, you have to uphold client interest. You have to try to defend in the best possible manner. To opposing counsel, maintain partisan stance unless required by law to assist an adversary. Maintain a position that the opposite representative usually holds in the court of law. Conduct communication with opposite counsel in professional timely manner. Refrain from communicating with the represented party without lawyer's consent. To the court, there is a duty of a lawyer to maintain dignity, decorum, courtesy of the courtroom. Refrain from expressing personal opinion on the merits of client's case. Avoid misleading, deceiving the court. Disclose relevant legal authorities to the court. Abstain from appearing before the court while under the influence of alcohol or drug. What are the duties to other party? Ensure accuracy, candor, comprehensiveness in presenting the client's case. Avoid any unfair advantage when communicating with unrepresented or vulnerable party. Encourage unrepresented parties to seek independent legal representation. Clarify lawyers' role when interacting with self-represented litigants. Refrain from taking any undue advantage of them. To society, refrain, stop yourself from abusing any legal process for any bad, malicious, harassing purpose. Avoid any kind of dishonesty, dishonorable conduct. Prioritize best interest of children whenever any such procedure is there, any such proceeding where impact is on the children welfare. Avoid conflict of interest, undue influence on judicial officer. Uphold integrity of legal system by avoiding obstruction of justice. Ensure preservation of evidence. Then comes civility. Civility in legal profession means treating each other, all participants, whosoever is involved in the justice system, with politeness, with courtesy. In examination, many times you get questions regarding civility as well. This topic comes into picture when there is some scenario where it is directly mentioned that you as an advocate has cursed or you started shouting during the proceeding on your other opposite counsel. So there you have to bring this thing into picture when you have to decide on professional misconduct also. So there was a case of Groya versus Law Society of Upper Canada. Basically, in this case, disciplinary proceedings against a defense lawyer for uncivil behavior during trial procedure came into picture. So Supreme Court of Canada considered the approach for assessing whether in-court incivility amounts to professional misconduct exactly based on similar facts of this question. When I wrote professional responsibility, I got question in examination. Law Society Appeal Panel recognized importance of civility while remaining sensitive to lawyers' duty of resolute advocacy. So they said there should be a balance between your zealous representation and importance of decency in the court of law. So panels approach balance flexibility and precision by considering contextual factor like what was said by the lawyer, how it was said, judge reaction, allegation of prosecutorial misconduct cross into professional misconduct unless made in good faith with reasonable basis. Challenging opposing counsel's integrity based on a sincerely held but incorrect legal position is not professional conduct. The professional conduct must have something sufficient foundational factual basis. Advancing a novel legal argument, even if ultimately rejected by court, it is not professional misconduct. For example, you are abusing your co-lawyer, that is incivility. So court dismissed the charges against Mr. Groya, emphasizing that question of incivility purpose was not whether he was right or wrong or law, but allegations had a factual basis or not. This was the question. So here there was no incivility. Next, in the case of Laraker, Gary Laraker went on the offensive after client claimed to him with a $500 demand letter from Toronto lawyer Patrick Martin writing on behalf of Hudson's Bay Company. Letter cautioned the woman whose daughter had allegedly shoplifted that she could be liable for an even greater damage claim if she didn't pay the settlement amount. So, in a fact, rejecting the settlement offer, Laracle alleged Martin was involved in a scam. Save the postage in future and become a real lawyer instead. You must have harbored dreams of being a good lawyer at one point. Surely bullying people into paying some small amount of money is not what you went into law for. But then again, someone has to be at the bottom of the class. So this is what he wrote. So he wrote for the other lawyer. So Laraker left commentary on an online discussion thread. Martin made a complaint to Law Society of British Columbia about respondent's remark containing letter and the blog posting. Law Society contends that this is incivility. Whether respondent's letter, the issue was, and the blog post in regard to Ontario law was uncivil, discourteous, amount to professional responsibility. So what were the tests involved to decide this question? Whether the fact as made out disclose a marked departure from that conduct of law society expect of its member, whether it was completely unprofessional thing or professional misconduct. So conduct of respondent must also be culpable, blameworthy. Conduct unbecoming a lawyer, defined as a conduct that is deemed in the judgment of bencher or the panel to be contrary to the best interest of public or legal profession, harm the standing of legal profession. Then professional misconduct is defined in the rule conduct by a lawyer in lawyer's professional capacity that tends to bring discredit upon legal profession. So online commentary could be deemed a mixture of both conduct of respondent's private life as well as lawyer's practice. Then letter cannot be considered as deemed as conducting unbecoming a lawyer. It was undertaken and executed within the respondent's legal practice. So in both Lanning and Greene, the respondent uncivil conduct was found to be professional misconduct. The duty of courtesy and good faith applies to all counsel. Canons state the personal remark or references between lawyers should be scrupulously avoided. This is not what to expect from a decent lawyer. So, what was held? It was held that the letter to Ontario lawyer and blog posting definitely. Then coming to document production, so pre-trial advocacy decision. So firstly, you have to consider the client's case objectively, determine the goals, how you are going to settle, whether the actions align with court's purpose, then you plead, you draft. So do not contain unnecessary, scandalous, prejudicial allegations based on the client case. Ensure pleadings are truthful, relevant. Then avoid instituting or prosecuting matter motivated by malice, like there is baseless case or you are just making up a case. In DCB versus Zellers Incorporation, what happened? There was a 14-year-old son who shoplifted in Zeller. He took goods worth around $60. They were returned intact and unharmed. Legal counsel for Zeller wrote to the mother demanding restitution of $225. So counsel stated that if this amount was not given, the store would proceed with a civil action against her. So you can see the legal counsel for Zeller just wanted to make up more money from the mother of this 14-year-old son who returned the items. So DCB paid 225. However, after seeking legal advice, she sought the return of money. Can the plaintiff return the funds on grounds Zellers never had a valid claim against her personally? So there is no such general rule that parents are liable for the torts of their action. They are only liable if they were behaved in a negligent manner. The store did not have a valid claim against DCB as a parent. So this is very important. Now next is discovery process. So lawyers should follow procedure rules for discovery, provide relevant information quickly, promptly, balance client interest with the duty of full disclosure, cooperation during discovery, ensure discovery process is conducted with integrity, fairness, and you are preventing any abuse, concealment of relevant information. So with regard to discovery, there is an important case of Grossman versus Toronto General Hospital. So here the plaintiff brought a claim against hospital for negligent care of their loved one. He was hospital, went missing for 12 days. He was found on 12th day. His body was decaying, duct work of hospital. At the time of production of document discovery, hospital produced only one thing, the chart. The motion was brought that the hospital should produce further documentation. If there is a difference of opinion over whether a document should or must be produced, the court has the power to decide the issue. Production is obviously open to serious abuse as the integrity of system depend upon willingness of lawyer to require full and fair discovery of their client. Duty upon a solicitor is to make full, fair, prompt discovery. A party giving discovery is under a duty to make careful search of all document. So the hospital has to give all documents, all the material document which may be in the possession of others for him. Solicitor has a duty of careful investigation, supervision, advising client of as to what documents should be included in the affidavit, because a client cannot be expected to know the whole scope of his obligation. Here, the plaintiff did not know everything, so it was the lawyer's duty to tell plaintiff that okay, we need all this further document. So a motion was brought further that the hospital should bring forth, produce further documentation. So during trial, there are few tactic, evidence and disclosure manner. So while preparing any witness, it's lawyer's duty to ensure that the witness is properly prepared for trial. Witness understand what to expect and ensure they tell the truth. So there is a fine line between ethical preparation and unethical coaching, which could involve coaching the witness on what to say. Ethical considerations include avoiding any suggestive questioning, not counseling witness on evasive evidence. So Canadian justice system relies on honesty and integrity of counsel who practice within it. Every lawyer is an officer of court who attempts to obstruct justice, breach his own duty as an officer of court. This was held in R versus Suizia, so this is important. Then coming to cross-examination, this is again important step during trial for uncovering the truth, but this must be conducted within ethical boundary. Lawyers must not put suggestion to witness recklessly knowing present false fact. There are also limitations like when there are any sensitive cases related to sexual assault. So their fairness and respect for dignity of the individual involved whom you are cross-examining comes into picture. So there are many different cases, extra cases that I have added in the notes. So you can follow those. Here is one case that we can discuss here. So R versus Ossolin, in this case, it was held that cross-examination must be permitted so accused can make full answer and defense. Right to cross-examine is protected by Section 711D of Canadian Charter. General rule is that in most instances the adversarial process allow wide latitude to cross-examiner to resort to unproven assumption, any innuendos in an effort to crack the untruthful witness. So this was happened in R versus Sharing. That okay, you are allowed to grill a person to the extent you want, but there should be a balance. As long as counsel has a good faith basis, a function of the information available to cross-examination, his or her belief in its probably accuracy, intent of which it is used for asking on otherwise permissible question in cross-examination, the question should be allowed. So it's okay if you are resorting to any unproven assumptions or anything, as long as you are doing it within your authority as a lawyer, within good faith basis, and within your zealous representation of making your client win the case, you are good to go. So lawyers have a duty to disclose any error, omission that would breach professional rules, or if some documents have been asked by any client once the litigation ends. So the lawyer cannot keep any such document with himself or herself. They have to disclose all those things. There may be instances where clients prefer non-disclosure of personal region, and lawyer must carefully balance their duty to client with their professional obligation. So other ethical concerns include accurately, properly representing facts to the jury, summarizing the law properly in closing argument, informing the court of relevant legal authority, objecting to any inappropriate questions during cross-examination, and presenting reply evidence ethically properly without following any kind of illegal manner. So last is witness preparation, how a lawyer can prepare witness, conduct and perjury. So hypothesis is lawyers are allowed to pursue any hypothesis whenever they are doing witness examination that is honestly advanced. So they can ask any question like through reasonable inference, experience, or any intuition. However, they cannot make any suggestions to witness recklessly or when they know that they are definitely false. So this basically it shows that examination process is fair and truthful. Then lawyers must not improperly, illegally dissuade a witness from giving any evidence or advise a witness to be absent. Then lawyer must not knowingly permit a witness or party to present in a false, misleading way or allow any kind of impersonation. Impersonation means when you are not a person that you are representing, you are basically being representing some other person by faking up your identity. Then lawyers must not needlessly abuse, hector, harass, inconvenience any witness. So in Blank versus Canada Minister of Justice case, the Crown laid series of charges against B and his company, which was later quashed. Subsequent fresh charges were also stayed. Here, B sued federal government in damages and requested access to all records pertaining to prosecution of himself and company. His request for information was partly denied as only some of the documents were released to him. Government claimed solicitor-client privilege on others which they claimed were subject to litigation. On an application to motion judge, it was held litigation privilege claimed on documents excluded from disclosure by the government expired when the litigation expired. So now there is no litigation anymore. So therefore, the documents that the government disclosed, the documents that the government excluded and did not disclosed. So this thing basically now does not stand valid as the documents are no more subjects of litigation. So the government here has to provide all the documents that the party asked. So the government, basically minister who was claiming on behalf of government, so his claim of litigation privilege fails. The privilege has expired because the files to which B seeks access relate to penal proceedings that have terminated. Litigation privilege is not directed at, still less restricted to, communication between client and solicitor. It contemplates as well communication between solicitor and third parties, any unrepresented litigant. So purpose of litigation privilege is to create a zone of privacy in relation to any pending or apprehended any upcoming litigation if might arise. The common law litigation privilege comes to an end absent closely related proceeding upon the termination. So the moment your case is shut, your litigation privileges that you have as a lawyer solicitor also